Court's back in session. May be seated. Silence all cell phones.
So understanding that Trooper Williams is testifying tomorrow, and I gather that he is the witness through whom the defense would seek to admit the text messages between Ms. Church and Mr. Fowler. I think we should have a discussion about those. We can discuss anything else either now or tomorrow morning, including proposed redactions or disputes about the second recorded interview. But with respect to the texts, let me make a few observations, unless the council has something. Have they come to some agreement now?
We have not come to any agreement yet.
All right. Well, let me make a few observations to set up our discussion of the texts. I've reviewed the texts between the defendant and Mr. Fowler, which are, as far as I can tell, over a 10-day period leading up to Mr. Fowler's death. That is, they're from November 2nd to November 12th, I believe, of 2022. It appears, as I think the Commonwealth had indicated to me, that the majority of them are explicit sexual talk between the two correspondents. Although I can't see what links Mr. Fowler was providing to Ms. Church in these texts. I can see there's little thumbnails, photos of some kind. I can't really see what they are. But I gather from the text commentary back and forth that he was sending Ms. Church pornography clips, and that the clips involved, again, I gather from the correspondence, a number of men having sex with a woman. And the texts appear to reflect, I guess what one might say was an intense and highly sexually charged relationship between Ms. Church and Mr. Fowler in that time period in November of 2022. That being so, I can see two potential bases for admission of the texts. The first, which was the reason cited by defense counsel, is in aid of a Bowden defense. The defense contention, as I understand it, is that given that investigators had access to the texts, a review of the text should have led them to question whether the defendant was the appropriate principal suspect. I'm not exactly sure where that, according to the defense, should have led them, but that, I gather, is the gist of the Bowden contention with respect to these texts. The second basis for admission or potential admission is that the texts could be viewed as reflecting a state of mind by Ms. Church during that time period that is, I suppose one would say, certainly not homicidal with respect to Mr. Fowler. One of the things I want to bring up is that if I accept that the texts have some relevance for those two purposes, I question whether those purposes wouldn't be fully served by asking the lead investigator, that is Trooper Williams, to affirm the tenor of the text by simply having counsel describe their gist in more general and less explicit terms than the texts themselves. I don't purport to know how most people would react to reading this text correspondence, but I have to imagine that there may be jurors who are somewhat appalled and disgusted by it. Not only are the texts sexually explicit and graphic, with much discussion about, at least as I can understand it, whether on a planned trip to New Hampshire, the defendant and Mr. Fowler can recreate the scenario depicted in the pornography links with multiple men having sex with Miss Church while Mr. Fowler watches. But there are many statements by both of them that could be viewed as racist, or at least as perpetuating racial stereotypes about black men. The text may be seen as highly offensive by some jurors, and I would expect maybe by nearly all of them. Mr. Scully, I ask you, have you made a reasoned strategic judgment that it would be advantageous to Ms. Church to seek to admit all of these texts rather than eliciting a description of them?
You bring up some good points. So
Well, I mean, you can't read these without thinking, why in the world does the defense want the jury to get this particular portrait of Ms. Church?
Well, guess Your Honor said it very succinctly. This shows that her state of mind during that period was not homicidal. It would be great if it was much nicer and more palatable and more mainstream and, you know, more acceptable to many eyes, I think. And it's just not what we have. So I have to make a choice. Do I want the non-homicidal state of mind text or not? And the choice is we do.
Okay, I mean, I just wanted to make sure. I had no doubt that you and Mr. Norkunis have thought about this, discussed it fully with Ms. Church, and I want the record to reflect that because there's certainly a potential downside to this. It certainly doesn't seem to cast either of the correspondence in a light that's going to that is, I think, flattering in the eyes of most people who would be reading them. This is, in any event, I just want the record to reflect that you understand how these can be viewed by jurors, and there's a reason why you want these texts in. This is you've told me that you have, and you might have preferred them to be written in a different way, but they are what they are, and you think you need them. Is that a fair statement?
That's a fair statement. That said, if the court is inclined to let that universe of text in.
Well, I will tell you right now, I'm not letting any text in once the correspondence is stopped. It appears to me, and you can correct me if I'm wrong, but the very last text by Mr. Fowler is on page 5280 at 5:27 a.m. And so it appears that he is texting, and right up to that last text, he's still texting basically about these sexual matters. But that's just hours before the ambulance is coming. Am I correct?
Right.
But there's no texts after that one, and so every text by Miss Church thereafter is not a correspondence. It's not a back and forth. It's a soliloquy by her at a time when she knows she's not getting a response, and I don't see a basis for admitting those.
So what I would say, Judge, is we have.
And I haven't made a ruling yet because I want to hear from the Commonwealth, but I've told you I think there's some potential relevance for the texts up through that last one by Mr. Fowler at 5:27 a.m., and I'll hear from the Commonwealth after we've had our discussion.
So what the defense is thinking is we wanted to present the court with the universe of the text we're looking at, and you can now see, some of the problems we have. What I would like to do is separate them into two sections now. The first section up until the last text of Leroy Fowler that he replies to. That's section 1.
Okay.
And we would seek those in. My plan would be, I think, to follow the court's suggestion, ask Trooper Williams a little bit generally about the nature of those texts. There's nothing in them homicidal, something like that, to show the nature of it. And then to just offer it as an exhibit that the jury can look at later.
Without eliciting the specifics in any of the texts.
Shock and awe that it'll have.
Okay.
The other thing I'm thinking about that is now that, if the court rules that universe is admissible, what we would probably do is now take a second look at culling out some that we think are just unnecessary, redundant, inflammatory, so that we have a smaller subset, which I didn't want to do to start with. I wanted the court to see the full subset. But if that goes from 1,000 text messages to 500, it probably cover, or if that's the ratio, right? But probably the point is made, the state of mind point is made. But I didn't want to withhold anything from the court when you're making that ruling. So we would take a second look at now narrowing that set of text messages.
All right, I understand.
And then I could address sort of the second text message, which I agree stand on different footing.
All right. Well, first let's talk about the first section. Let me just hear from the Commonwealth on the texts up through Mr. Fowler's last text. Mr. Camelio, you've heard my analysis of the potential relevance, and
Yes. Well, 2 points that I want to make, Judge. First, with regard to access, which you had mentioned. So the search warrant that the Commonwealth obtained for Ms. Church's phone allowed the Commonwealth to look at text messages between November 8 and November 12. So when I had shown these text messages to Sergeant Williams on Friday when they were provided to us by the defense, Trooper Williams rightly pointed out to me that the ones from before the 8th were ones that he's never looked at because they were outside of the scope of the search warrant authorization. We were not allowed to look at text messages before the 8th unless they had a certain keyword in them, like poison or murder or whatever.
So the ones from the second, November 2nd to November 8th were not text messages that he was able to review?
Based on the search warrant, exactly.
So for purposes of the Bowden component of the analysis, at least a portion of these texts don't really.
They don't have, he didn't look at them, so they don't have any reflection on Bowden for.
Because he couldn't. It's not something he should have done and couldn't. Therefore, it was a fault in the investigation. He was following the parameters of the authorized search.
Exactly.
All right, I accept that. I think, all right, that's the Bowden component. There is the state of mind portion of it.
Yes, and while I think given the nature of the relationship between these two individuals, as it has been testified to over the course of the trial, I mean, I don't know how to describe it other than sort of toxic and dysfunctional. So I don't know that them trading what can only be described as sort of vile text messages between the two of them really go to Miss Church's state of mind with regard to whether or not she was homicidal. I think it goes far more to the state of mind of Mr. Fowler about whether he wanted to have some form of sex or watch some form of sex that Miss Church was participating in. But he's the one that's sending the vast majority of these pretty disgusting text messages. So one, I think it's an attempt to sort of smear Mr. Fowler, because I don't think it makes Miss Church look as bad as it does Mr. Fowler. I'm not going to say she's not involved or engaged back in these text messages, but for the most part, these are coming from him, not from her. So I think it goes to his state of mind. Her state of mind, I mean, she's agreeing, but I think it's a lot less relevant to her state of mind. And again, I think it goes to their state of mind about whether or not they were in a toxic and kind of vile relationship, but whether or not it goes to whether or not she was wanted to kill him on November 11th, I don't really see that it provides much support for that proposition.
Well, what I really ask myself is not whether your interpretation, which is a reasonable one, is the right one. It's whether a reasonable jury reading these texts could draw an inference that at that particular point, leading right up to hours before the ambulance arrives to care for Mr. Fowler, Miss Church was interacting with Mr. Fowler in a way that would be contrary to a contention that she was affirmatively trying to kill him. And I make the determination that the jury could. It's not the only interpretation, and that's what argument's for. You've made your points as to why you think that this speaks much more about Mr. Fowler than Miss Church. And I've also considered the 403 concerns about how this makes Mr. Fowler look, the decedent in this case. I'm very sensitive to the idea of whether this is just a smear of him, because it doesn't, I don't think, make either party to the texts look particularly good in the eyes of a jury. Yet I also understand that these are private texts between two consenting adults, and what they choose to say to each other when they think only the two of them are seeing these texts is really between the two of them. Now, it turns out that a lot more people are seeing these now, but I try to bear in mind that the way they struck me is not necessarily the way they'll strike everybody else. And Miss Church and Mr. Fowler had every right, if they wished, to interact with each other in this particular manner. But I do think that, on balance, I don't find that the probativity in terms of Miss Church's state of mind at a crucial time period is outweighed by the danger that the jury will really think ill of Mr. Fowler, the decedent in this case. I think there's a construction of the texts that would support a defense argument that Miss Church was engaged in what I refer to as a highly charged relationship with Mr. Fowler's at that point, and that may be contrary to a contention that she had a specific intent to kill him at that time.
If that's the case, Judge, if that's the court's ruling, I don't want the defense to be able to cherry pick out the ones that make Miss Fowler look the worst, and I want them all in. If we're going to put them in, I want them all.
Well, and so that's fine. Mr. Scully can engage in that exercise, but it may be that I agree with you. If some are coming in, they should get. It's a relatively short period of time. They should see them all. But I will tell you that I won't preclude him from telling me if he thinks there are some that should come out. But that's my ruling with respect. I'm sorry, with respect to the text up to Mr. Fowler's text on page 5280 at 5:27 a.m. Now, with respect to Ms. Church's unresponded to texts thereafter, Mr. Scully, what is it you wish to tell me about those?
So these would be texts from, well, Mr. Fowler was in the hospital. And again, I think it's the same two basic grounds. The primary reason that we would ask that they be admitted, or we do ask that they be admitted, is the state of mind of Miss Church, which was called into question, primarily by the witness Tammy Carbone, and secondarily by the witness Leroy Fowler III, who Tammy Carbone came up with her interpretation of Judy's silence being malicious. And coincidentally, what Judy does in those texts, especially at the beginning, is really explain so that Leroy can someday wake up and she has defended herself and can explain, how she was with him and by him and tracking him, and how she waited to notify the family, why she waited to notify the family, and so forth. So again, she has no idea, obviously, at this time, that these are going to be seized or searched. They're not statements, made in a furtherance of a self-interest. These are just her communications to the guy that she loves, who's now unconscious in a hospital bed, and she has received information that has made her think he's going to come through and prevail. And she wanted to have this explanation waiting for him. So I think that for the same reason, those are admissible. To the extent that they fall inside certainly inside the search warrant ambit, where I think there's still a Bowden issue is, as the prosecution is developing this very specific theory that law enforcement is developing, that she wanted to kill Leroy Fowler out of revenge for his relationship with Barbara Randall. I think these fly right in the face of that motive that they opened on. And that's my summary of how the motive that they gave at the beginning of the case. And that drove this whole prosecution. So I think that they should come in still, and under Bowden, the reason I think they should come in is that the Trooper Williams gets his search warrant. It allows a certain search of the phone. They should have looked at all these text messages in this area that they had access to, and then they should have seen which way those are going, which should have led them to look for more messages outside those narrower parameters. that they had the messages, I think, from the 8th to the 11th, and they saw or should have seen what was being said between these two individuals. And that should have led them to take a look at, well, what happens, on the next several days and what had happened on the few days before them. So I still think there's a live Bowden issue there.
I don't quite understand what you think a review of these texts do differently. The basic Bowden contention that they had access to some information that may, at least in your theory, undercut the Commonwealth's theory of a motive on Miss Church's part, I gather. But what you think the police should have done differently if they were fully comprehending your interpretation of these texts is what? What should they have done?
Well, number one, they could have presented them to the grand jury. Number two, they could have.
But presenting to the grand jury for what purpose? Again, I told you we haven't gotten back to this issue, but I don't see litigating before this jury the grand jury presentation. We're not. This isn't an Odell motion, so they're not going to be hearing claims that the grand jury was misled or was given incomplete information. The indictment stands as a charge, and we're not relitigating the indictment process here. So what, in terms of investigation, do you believe should have been done that these texts would have led the police to do?
Well, first of all, I think the stronger argument is under the state of mind. Okay. Second of all, under a Bowden or a bias issue, which I think are similar in this case. Okay. But in particular, there's a bias issue that what the police did is they didn't look at any other alternatives. They zeroed in on Judy. So they did the interviews, the interview with her on the sidewalk. They did the interviews with the Fowler side of the witnesses, the 4 witnesses at Mr. Eaton's house. Right. 2 days later, they interviewed Barbara Randall, and that was it for interviews. They didn't do anything else after that. In terms of investigating which way the case could have gone, Leroy Fowler's phone at that time had not been opened. They had it. They would have seen all this information because this was what was on it from Judy's phone. They also had access to Leroy's phone, all the text messages that they got because they got Barbara Randall's phone was presented right after her November 16th interview. And if they opened that and they saw it, they would have seen all of the abuse and emotional abuse and physical abuse that was documented on that phone. And I think they should have taken that all into consideration in bringing the charges against Judy Church, but they didn't. So I do think they had developed, all along, it's been our theory that they jumped to the conclusion that Judy must have done it right away, partially based on some Google searches that Trooper Williams did. The lab work wasn't back at that time. At the time they were arresting her, forget the grand jury, the time they arrest her, the laboratory work from NMS isn't even back. So we know at that time, I believe they had evidence at that time that Judy Church was arrested that he had died from ethylene glycol poisoning. They had a phone conversation with the medical examiner is what I think. I don't think they had an autopsy report at that time. They had seized these 2 items from her home, one being Powerade, one being the Rain-X, okay? At that time, they thought, oh, we've got it. 1 + 1 = 2, there it is. But they hadn't even done the laboratory testing, so there was not even a laboratory test yet that said that even the Powerade contained ethylene glycol, right? And they had the Rain-X, but they hadn't, it says it contains a bittering agent, but they had done nothing with that. And then most importantly, at that point, what they also hadn't learned is that the Rain-X, which was originally thought to be the likely source of the poisoning, is scientifically excluded as the source because there's such a small amount of ethylene glycol by percentage in the Rain-X and such a large amount by percentage in the fluid from the Powerade that it can't be from each other. And yet, they didn't pause 1 second and consider anything else.
So, yeah, I understand the argument is, generally speaking,
Yeah.
You contend that there was a rush to judgment on imperfect and incomplete information, and that's something you're going to be permitted to pursue. I have no doubt you're going to be asking about, the NMS testing and why no test for a bittering agent and all those sorts of things. But what I'm focused on right now is whether these texts after Mr. Fowler goes off to the hospital should come in. I'm going to go back and look at these, each of these. I will tell you, though, that I start with a disinclination because these texts are being sent by Miss Church after Mr. Fowler has gone off to the hospital with what we ultimately know or come to know was, lethal ethylene glycol poisoning. It's like somebody, a defendant, just deciding in the midst of the events leading up to an arrest to take out a recorder and start putting down all their thoughts and then say, I want the jury to hear these things. That's what this is like to me. Mr. Fowler's gone off to the hospital. He's in dire straits. We've seen what he looked like on those videos that Miss Church took. And she's taking this time to put all these things down in these texts that she knows he's not going to be responding to. And many of them would strike an objective observer as self-serving statements by her. And so I have a disinclination to say, oh, these come in as valid state of mind statements by Ms. Church. I'm going to look them over, and we can have a more focused discussion once I've had an opportunity to do that. And so we'll table that discussion until then. I remind you, Mr. Scully, of what I'm sure you already know, but Mr. Camelio made reference to this way back when we started discussing Bowden, but there is pretty broad leeway given in Bowden rebuttal. And so when you're asking questions of Trooper Williams, why not this, why not that, why he's going to be permitted to give his explanation for why the focus was on Miss Church and not on other people, including who had access to the Powerade bottle and all these other things.
Right, I recognize that, but the Bowden in this case is very specific too. We're not challenging specifically under Bowden grounds what happened, and basically until they have all the evidence that they've seized, the phone seized, all the evidence from the search warrant seized, right? Now the Bowden defense is, what do they do with the lab? It's all laboratory stuff, right? The rush to judgment is a bias issue, not a specifically Bowden issue. So when we're talking about your interview with 4 people and maybe rushing to judgment, that's not necessarily Bowden. So what did they not do? What would they have done differently, now that they know we're challenging the lab stuff?
What is a bias issue? I know what bias is when there's a claim that a particular witness is biased such that the jury shouldn't credit what the witness is saying. But you're talking more generally speaking of sort of generally an overarching antecedent bias against Ms. Church. But ultimately, this case rises or falls on the evidence that's presented in this courtroom. So what's the bias issue you're talking about?
Well, it strikes me that that interview on November 14th with the family members at William Eaton's house, that those people got together and decided to tell police what they thought that might connect Judy Church to this case. And essentially what the police did is try to solve the whole case in one meeting. That's it. That's basically there it is. We got the whole answer right here. They interviewed Barbara Randall after that. And John Haywood pops up out of the blue 2 years later. So he's not really part of the investigation. He just pops up in the middle of the litigation, I think after the motion to dismiss case was heard. And there was some media on it, but setting him aside. So I think that's the bias. It's not racial bias. It's not necessarily gender bias, although you wonder. It's that, they wanted to resolve this case quickly, without necessarily doing any more work. And I think that's a bias that we developed, a law enforcement bias.
Well, you calling it bias, I think that is a form of Bowden. It's still a claim that it was a rush to justice with an incomplete and imperfect investigation for various reasons that you wish to highlight for the jury, and you're permitted to do so. But anyway, I don't think we need to belabor that.
Yeah, right. What I really don't think we're opening the door to, is anything that was excluded in terms of when she lawfully said, I don't want to let you search my house. No, you are not opening the door. Someone standing on their constitutional rights, that door doesn't really get opened. So what I'm talking about is if the questions is asked, a trooper's generally permitted to respond why they thought that the evidence was strongly leading them in one direction. In this case, it may be whatever Trooper Williams may choose to say, but I would imagine the fact that Mr. Fowler's living with Miss Church, there's a bottle found in the recycling that has this liquid that ultimately they think is the murder substance. Nobody else is there. She's the one who has access to it. All those sorts of things. Those are generally fair rebuttal to a contention that they should have been looking elsewhere, doing other things. Fair enough. We're on notice. I don't know where the Commonwealth's going to go, but my biggest
I don't either.
constitutional issue.
No, I don't. Who's handling Trooper Williams?
I am.
Yeah, we're not talking about any belief on your part the door's been open to say Miss Church wouldn't let you search her house without a warrant, would she?
I can't imagine that door being opened.
Nor can I.
But I mean, I guess if it is, we'll come to sidebar first. But I do expect just about everything else that has been sort of discussed in motions in limine and things that I obviously chose not to put in because it is, it might have been hearsay or whatever. That stuff is all fair game on Bowden. And I do expect all of those statements that are attributed to Ms. Church by various witnesses or attributed to Mr. Fowler, by various witnesses about what Ms. Church said. I do expect all of that to be Bowden-related rebuttal. So I made that pretty clear in the motions in limine last week, and I think the court is fully aware of that. So I do expect that as far as I'm concerned at this point, the Bowden door has been kicked as wide open as possible based on the opening and the cross-examinations of various witnesses here, both in terms of what the police knew prior to Mr. Fowler's death or what they did at the lab after. This is the entire defense has been Bowden and
right.
with hints of third-party culprit. So I'm not looking to put in anything that is a constitutional right for Ms. Church. I'm not, I don't expect to say, oh, you had a lawyer, and you stopped talking. Obviously I'm not doing that, but everything else is fair game.
All right. Last thing, Mr. Camelio, just before I recess and take a look at those texts that came after Mr. Fowler went off to the hospital, is there anything you want me to think about in reading those texts?
Well, yeah, the court made a point the other day that, we used to have a state of mind exception that basically swallowed all the other hearsay exceptions, and that's no longer the case. And this is classic denial by the defendant, which the SJC has told us is not admissible. This is a statement from the defendant, I did not commit the crime, right? I mean, that's the summary of what these 25 or 30 text messages are. And to allow a defendant to, as you said, either write it all down or do a taped deposition or a taped statement where they explain all the reasons why they're not guilty. I mean, if they want to put that stuff in, they should got to testify.
Well, I think you're conflating two separate things a little bit in terms of what the SJC says. When they talk about exculpatory denials being inadmissible, first of all, I'll say it, I've said it umpteen times, I don't understand why the SJC says that. In the context of an interview, it seems, and defense usually don't stand on that particular objection. Context of an interview where there may be incriminating statements, generally speaking, I think it's appropriate for the jury to hear the denials as well to understand the full tenor. But what I was making reference to the other day is the fact that the SJC has made clear that the state of mind exception does not apply where you have to believe the truth of the matter asserted in the statement in order for it to have relevance to the declarant state
I
of
do
mind.
think that is exactly what
And
it is.
that may indeed be what's going on here. And so when that's the case, the state of mind exception does not apply because it's essentially not a hearsay exception. It's the truth of the matter. So I will be, that's why I want to go back and look at the text.
The one other issue that we really do need to deal with today, and we can't do in the morning,
Oh,
is
okay.
the interview of Mr. Fowler, Miss Church.
Oh, you need to make the redactions.
And
Okay.
there are two that we are sort of in dispute on. One, there is some discussion. Trooper Williams or Detective Ernie asks Miss Church if she would take a polygraph. There's some discussion back and forth about that. She eventually says yes, but not today. A week later, we get a letter from a lawyer saying, "Don't talk to my client." So there's no chance of doing a polygraph. I think getting into any of the polygraph is going to get into the reason why it didn't happen is because we got this letter from a lawyer that said, "Don't talk to my client." I think that's just not worth getting into. I don't see any relevance to the polygraph where she says, "Yes, I'll do it, but not today." It just seems like a nightmare to litigate that whole thing. I ask that the court take that out of the statement.
I don't have a copy of the statement.
I can give. I thought you did. I
Did I?
apologize, Judge.
I have a transcript of the statement.
I thought you had been given one, but it might have been only interview number one.
The only thing I got was a marked up interview 1. I never got a marked up interview 2, to my knowledge.
Right, you have, we have C for ID, which was,
Is that number one?
I don't think that's it.
This is Tammy Carbone.
sorry,
I'll provide it.
thank you.
And Judge, the other issue,
Sure. Can we keep this, Mr. Camelio?
yeah, I'll print another copy.
All right.
Thank you. This will be,
The- And then and so that takes place on page, actually, it's at time, right?
There were agreements that we had that were already taken out. I can provide the court the highlighted portion that I flagged yesterday of the two things that I thought we had missed that should come out. I think those are the things that are in dispute. I believe this is an agreement for the first part.
I'm sorry, I was looking at this transcript on the interview, so
So Judge, it's at, starts at 1:17:52. It's towards the end, obviously.
11752.
Yep.
Is this one of the ones you're talking about, Ms. Strasnick?
This is, it's one of the two that we're, I guess, not in agreement about, Judge.
this is the statement, I did not do it.
No, this is the, would you do a polygraph?
Oh, would you do the polygraph?
At 1 hour, 17 minutes and 52 seconds?
Yes.
Oh, yes. Okay, now I see it. Would you do a polygraph so we could just clear you and move on to the next person? Okay, and she says yes, but of course my heart is like being yes, but yes, absolutely nothing to hide. Okay.
And then she goes on to say, "I don't want to do it right now. Please don't." That's at 1:18:31.
Oh, yeah.
All right, so what, you are proposing redaction of what, Mr.
I'm
Camelio?
proposing redaction starting at, would you do a polygraph, up until Ms. Church says, "I don't want to do it right now, please don't."
Okay, I've
Which
got,
which seems to convert her, "Yes, I'll do it," into a "No, I won't." And then obviously, as I told the court, we got a letter from her lawyer at the time saying, "Don't talk to my client, so no more polygraph."
okay, all right, that's one of the two, and what's the other one?
The other one is right at the end, Judge, and it is at, yeah. It's at 1:34:05 to 1:34:27 in that box, and it's at the end. She says, "I did not kill that man. I think I need a lawyer. This is starting to get ridiculous to me, and I think that I did not kill that man should come out because I think it's made in the context of I think I need a lawyer, and I don't think it's fair to leave the denial in without the full statement, which is I think I need a lawyer.
Why does I did not kill that man? Why do you think that's linked to I think I need a lawyer?
Well, I just think because she stops and she says we're happy, laughing, and no, I don't, and then she says I did not kill that man. I think I need a lawyer. I don't know how to read that without those two things being part of the same thought process of Miss Church.
So you're proposing just a redaction of, well, right now, aside from I did not kill that man, you've agreed, by agreement, I think I need a lawyer is being redacted?
Right, and pretty much everything that falls after that is a discussion about the lawyer. So
so the agreed redaction, starting with I think I need a lawyer, goes down to what?
to the end. Yeah, I think it goes all the way to the.
Is that it?
There's one block at 1:36:17 where Trooper Williams says I'm going to end says I'm going to end the interview right now.
So it's the only thing the jury hears after that is I'm going to end the interview.
Yeah, he says the time is now 5:36. I'm going to end the interview. Okay, I have my card here, which I didn't have the other day. He gives her his phone extension.
Okay.
Says they'll give her a ride back to her house.
Okay, so by agreement, there'd be a redaction from I think I need a lawyer at 1:34:27, all the way down to when Trooper Williams says the time is now 5:36. Okay.
And everything that follows after that, from 1:36:51 to the end, is also coming out.
Okay. All right. So the second dispute is about whether or not a single line gets redacted, which is I did not kill that man.
Yes.
Okay. All right. Has she not said that before during the course of the interview?
I don't know that she says it in exactly those words, but yes, she asserts her innocence at other parts of the interview.
Okay, I'm not going to require a redaction of that. I don't see the reason for it. With respect to the first redaction, I don't see the reason why the jury should be hearing about the polygraph. They go back and forth. The polygraph ultimately wasn't done. The lawyer got involved. Polygraphs are not admissible. I know that doesn't mean that statements about them might not be, but I don't see why that should be in there, given that she said yes, and she said, I don't want to do it right now, and then ultimately, with a lawyer involved, she didn't do it. So I would agree to that redaction. So those are rulings I make.
And just note our objection on the polygraph, Judge.
Yeah.
I agree, it kind of cuts both ways, that she said she would do it and then sort of backed off a little bit. We viewed it as the police were basically misleading her with an offer, like daring her, trying to get her to make an admission. I think they did something similar when they suggested her fingerprints were found on antifreeze at her house earlier in the interview, and she's like, at least that's my memory, that they found antifreeze. They didn't find antifreeze. And my memory is that they said something about her fingerprints being on them. And so there was a little bit of this, sort of enticing her to see if she would admit that she did something wrong, which she adamantly denies the whole time. So we saw it as coming in on that. Just note my objection on that.
I do. All right. Anything further? Mr. Camelio, you look absolutely shocked and dismayed that I've made that ruling.
I guess I apologize for my lack of a poker face, Judge. I just don't understand how a denial, it's just a straight denial by the defendant that doesn't provide any context to the rest of the interview. And so I guess I'll have to go back and look at the law, but my understanding of straight denials by the defendant that don't shed any light on any other portion of the interview are not, I don't have to admit it, right?
Well, you're right, and I guess I wasn't thinking about this in terms of the doctrine of completeness, because and I don't know how much has been taken out, but where you're putting in, a substantial interview, I have to believe that there's all kinds of things that are in here that are not just the cherry-picked statements that the Commonwealth has chosen to put in and anything that may be necessary to explain those particular statements, which the Commonwealth has a right to do.
Right.
They could put in a statement on page 1. They could put in a statement on page 10. But where that's one of the reasons why I ask is she making professions of innocence
She makes,
elsewhere?
I mean, like I said, she never comes right out and says, I did not kill him. She does not. She never admits to having done anything, and she doesn't admit to having, killed him. Obviously she makes no admissions. Otherwise, I'd be putting those in specifically or highlighting those specifically. But I guess my feeling and my understanding of the law is the Commonwealth can put in whatever portion of the statement it wants to. The defendant can only put in statements of the defendant that are subject to the rule of completeness. That statement, in my view, is not subject to the rule of completeness. So Well,
you're right. You're right. It's not necessary. I'm looking at what's immediately coming before it, which is some discussions about how is she coping with him leaving and going to Barbara's, and then she says she gets upset. I don't do anything about it. He comes home and he has little ways of making it up, and we're happy and laughing and no. And then she adds, I did not kill that man. So basically what you're telling me is you're offering the first part of that, and that the I did not kill that man is not explaining anything about what she's just said that you are offering.
Correct.
All right. So now we're focused more on the doctrine of completeness and what the Commonwealth is choosing to put in. It's just choosing to put in a lot of this, but Mr. Scully, why is that not correct? That statement doesn't shed any light on the statement right before it that the Commonwealth is choosing to put in.
I think it does in context that what Judy Church has been faced with is a series of accusations and an unfolding amount of evidence that they're disclosing to her, some of which is not true, including that they found antifreeze at her house. And then they spring these notebooks, which they've just recovered in the search, on her, and her response to this cumulative interview is to say, I did not kill that man. And it's the first time she says so specifically, because it's the first time after all of these suggestions that she has done something wrong and that the investigation is focusing on her and that evidence is building against her. This is her response to that. It's not to just one sentence before it. It's to everything that came before. There was also the sidewalk interview in the background. But really, the building momentum here of the police interview into an accusation. And I think it's unfair because that's how it reads when you see it. And she would be expected to make a response at this point.
Well,
and she says, I did not kill this man.
That's that's not an expected response to anything that's under discussion right then and there, and it doesn't shed light on anything that I see is immediately before it. I don't have the benefit of simply saying, let me go through all this again and I'll finalize my decision, because the thing has to be edited so it's ready to go first thing tomorrow morning. I understand your argument, Mr. Scully, and I know that I'm reversing myself here, but that's why I always try to be open-minded about such things. But I don't see that statement as shedding any particular light on anything that's said right before it. And if she makes no overt admissions to anything, I take it, in this interview, Mr. Camelio?
No, Judge, she does not.
So it's not like it's needed to understand that she may have said, I did something, and then she's taking it back. She's made no admissions to anything in particular, so it's really just a freestanding assertion of innocence, which doesn't really shed light on anything else. So, no, I think on further reflection that the Commonwealth's not required to put it in, and I don't think that statement is necessary for the jury to fairly consider the statements that are being put in. So that too may be redacted. That's it for today.
Thank you for
I do.
One more thing to add, if I could, Judge.
Okay.
Sorry to everybody. As a court, so note our objection to the court's rulings. As the court's going back to consider now the potential admissibility of ongoing text messages that Judy sent to Leroy when he was at the hospital. One other thing that I just want to put on the court's radar screen is that in assessing her state of mind, take a look at her text messages that she had been sending all that evening and that Leroy had been sending to her. Because what it shows is that Leroy had excellent dexterity and a focused chain of thought process all night long. Okay, we know on Thursday he was good because William Meaton saw him and talked to him. And then all night long, he's texting her, he's sending her links, he's proposing scenario. There's a lot of dexterity involved with that. Clarity of thought and dexterity, hand-eye coordination, all being sent to Judy, which goes to her belief that he's going to be okay, which is what she's basically under the impression of when she is cut off from being in the medical care, which goes against the idea, I would submit, that these are self-serving statements and show that they are, true state of mind exception statements.
Well, anybody who observed what Ms. Church observed firsthand and videotaped and was shown to the jury would understand that Mr. Fowler was in pretty dire straits when he went off to the hospital. Something was grievously wrong. So he may have been dexterous in his texting up to 5:24 in the morning, but by 8 a.m., he was in serious and dire medical condition. So that was the reality at the time of those texts. But I'll read over the texts and we'll have that discussion. We'll be in recess till tomorrow.
All rise.